This question is, what should I expect at a first hearing dispute resolution appointment? So if we break this down to understand it a little more, it is a first hearing, so it will be the first time the court has properly heard arguments from either side. But it is also a dispute resolution appointment, so it should be seen as an opportunity for both sides to come together with the assistance of the court in various aspects, but also usually with the assistance of their legal representatives, assuming they are resolution focused as they ought to be. It should be used as an opportunity to resolve the issues, or at least some of the issues, between parties whilst you are at court and focused on the issues at hand. That being said, the court's approach is going to be to try to narrow down some of these issues. You may even find that the court will tell both parties that something that they consider to be an issue really isn't, and the court may decide there and then to eliminate it from the arguments. Aside from this, the court is going to want to narrow down what the key issues really are and why each party is opposing one view or another. This is so the court can get an idea of what the core issues are that the court will ultimately be asked to decide. And this is for various reasons, because the issues will determine how much evidence the court is going to need to hear, what level of judge is going to need to hear the evidence, and what sort of time frame is going to be needed for the court to hear the evidence. And that can also include various other evidence and reports that may need to be gathered in the intervening period. For example, each party may be asked to go and get certain evidence that they will intend to rely on later on. It may also allow time for Section 7 reports, which the court may ask various things to be investigated and reported back on to the court, so that the court has that information before them. For example, a CAFCAS officer on the case may be asked to report on specific conditions of the house, if one party is alleging that the house conditions are not suitable for children. You should expect to be at court for the majority of the day, or indeed you should make yourself available for the whole day, because even if a hearing is only listed for 1 hour, the court will expect you to use that time at court to try to resolve these issues. So your time in court may be as little as 15 minutes, but the time surrounding it and trying to resolve these issues between parties and between lawyers and with intermittent help from the court will expect you to try to resolve these issues. Ultimately, if there are issues outstanding, then the court will make various orders for delivering that evidence and setting a date for the next hearing. If all goes well between the parties at this first hearing, you may well be able to agree an order between the parties, which the court can then endorse and turn it into an order that all parties must follow. So it's important to always bear in mind that you should always be trying to resolve the issues with the other party, because that is the minimum expectation the court has upon you.